So we've been seeing a bit of an uptick in my office on labor commissioner claims. I don't know the rationale or reason for that, but and it might just be an anomaly that we're seeing a lot of these claims coming through with our clients. But I want to talk about a few strategies employers need to understand in going into defending labor commissioner claims. So the process overall with the labor commissioner complaint, the employee, current or former employee, will file a claim with the labor commissioner. The employer will get a notice of claim in conference at the beginning of the case. Normally, most labor commissioners set this settlement conference up front first. And it'll have a date and a time to show up at the labor commissioner hearing. The employer is required to bring in certain documents, such as proof of workers' comp insurance. If the company's doing a DBA, the documentation about the DBA, and also articles of incorporation. Now, this first settlement conference, if the labor commissioner does set a settlement conference, is just an informal attempt to try to resolve the case. If it doesn't get resolved, the labor commissioner will set another date for the parties to come back at the labor commissioner office to have the actual hearing on the matter. Now, it's taking over a year to get through this process. The labor commissioner's been pretty backlogged here in 2018. So it does take some time, and employers need to be aware of the information that they need to bring in defending these types of claims. So for the settlement conference, employers should consider bringing documentation to support their defenses. If the employee is claiming they weren't paid all wages, weren't able to take all their meal and rest breaks, bring handbooks, any acknowledgments the employee has signed, and also bring time records if those are applicable. And then when it's set for an actual hearing, employers should be ready to bring in witnesses and other people that can testify to the extent the employee is claiming they worked off the clock or didn't get their breaks. Witnesses that will be able to testify that, no, I worked alongside that employee and I saw the employee taking the break, and I saw when the employee was working, they were clocked in. These witnesses can be from anywhere from supervisors to coworkers to maybe even patrons that are in the location, the customer's location, and saw the employees working. So it's really open, and these labor commissioner proceedings are really informal. So there aren't any formal evidentiary proceedings or rules, and the employer really needs to think outside of the box on what type of evidence to bring in to defend the claim. So I hope that helps explain the process and some strategies in defending a labor commissioner case. If you have any questions, please feel free to reach out to me. And if you have any ideas for future topics that you want to see me address, please let me know. Thanks.